In this video, we're going to go over the purchase and sales agreement. Now, this particular purchase and sales agreement is really designed for a wholesaler. There's a lot of terminology in there that benefits the wholesaler. So I just want to walk through and just cover everything so you know exactly how to use this form. All right, so you found through your driving for dollars, through your marketing, you found somebody motivated to sell at a wholesale price. The house needs work. They just need to sell it fast, whatever the reason is. So now it's time to put the house under contract. This is the form that you use to contract the property between you and the seller. All right, in the first section of this agreement, we have the date. Now, on the date of the agreement, you really want to try and to do this on the day that they're going to sign the agreement. So if you know you're meeting them, Saturday to go over everything, date it for Saturday or whenever, all right? So try the best you can to have this dated for the day that you're going to sign it. All right, and then next line here, we have the, who is selling the property. And you're always going to want to ask the seller who's on title. If it's, just one person, their name goes in here. And I have Harry, but, it would probably be Harold. So make sure it's their legal name that you're putting on the document. If it's a husband and wife, they're both on title, put them both in here. If it's two brothers, if it's cousins, if it's two friends, whoever, make sure that everybody on title is on here. If it's just one person, just put that person on there. All right. The next line, we've got the wholesaler. So this is going to be where your name goes. If you have a partner or you're co-wholesaling the deal, a lot of times people use JV agreements, and we're going to go over a JV agreement, but you can also just put both of your names right on here. If you're doing the whole deal together, just list both wholesalers right in this section. So that's all you have to do. All right. Third part here is just the property address. Seller agrees to sell and buyer agrees to buy the following described real property together with all improvements and fixtures and personal property described below. We put the property address, and then on legal description, I just put C title. You can look up the legal description if you'd like and put it in here. But I was in the real estate and mortgage business for years, and I always did this. And I'm sure I started doing it because somebody else was doing it or a lot of people were doing it. But when the title company does all the work, they're going to have the legal description on everything that everybody has to sign at closing. So just you can put this and it covers you and you'll be fine. Okay. Then we get down to the money portion here. And so we've just got it laid out here as if we're putting $100 down, earnest money deposit. So the total purchase price is $70,000. You're putting $100 down, and then the cash to seller at closing is going to be $69,900. So just to be clear, when you do an earnest money deposit or you give an earnest money deposit, it goes to the title company. It doesn't go to the seller. You don't give them cash. You don't write them a check. The check is made out to the title company that you're using for the closing. All right. And we're going to go over that right now. So earnest money deposit to be deposited with a licensed title company or attorney within 48 hours of acceptance and ratification of this offer. So when everybody signs, you have 48 hours to get that to the title company. If the contract is canceled by the buyer pursuant to the terms of this contract, buyer becomes entitled to a return of the earnest money deposit, and escrow agent shall immediately refund the buyer all EMD and escrow. So we're going to go through, the different ways on how you can get out of this contract, inspection or your partner's approval or whatever. But this contract just states that if you cancel this contract, you get your money back. Okay. Also, this earnest money deposit you put down, for any contract to be binding, there just has to be some consideration. Okay. So you can just make this $1 if you want to. And oftentimes I do. I just write $1 in there, or $50 or $100. And it's only typically an issue if you make it an issue. If you bring it up and you go, oh, I'm only going to put $100 down, then it's going to be an issue to them. But if you just put it in there, you don't mention it, and you just, go on, just act like it's what you always do, and it's not going to be an issue, like I said, 99 times out of 100. Okay. All right, moving on, the financing. In wholesaling, our deals are usually cash. Okay, we find a cash buyer, an investor, our list of investors, and they're all cash buyers. And we go to a deal. We want them to pay cash because we don't want them to get somebody to get stuck up on trying to obtain a mortgage, or they get turned down for a mortgage and then your deal goes sideways or whatever. So we want people paying cash, and the best people to do that are people that buy houses for cash all the time. Thus, you want to build the investor list. Okay. So we have the cash option on here. All right. We also have a seller financing option. So let's say you want to start getting properties in your own portfolio. You want some rental properties, or you want to start rehabbing houses and you've got some money to do the rehab or whatever. You can check here and put, seller finance with the following terms if they agree to it. And the only way I would do this, or the way I would suggest doing it, is just make your seller financing 100 payments of whatever the purchase price is divided by 100. So here we've got $70,000. So let's say if they would take payments, they're a older couple and they don't really need the cash, but they like the additional income every month. You could put in here seller financing option and make the terms 100 payments of $700. All right. And, that's going to equal your $70,000. Or when you're making your offer, to make it more attractive for them, say, you know what, I'll give you 70,000 cash, or I'll give you 80,000 if you'll take payments on it. So then, and they say, all right, well, I'll agree to that. And then you check here and just do seller financing with 100 payments of $800, all right, over, 100 months, which is, I believe, like 7.5 years or something like that. So you own the property pretty quick. You're not paying interest. You're just taking whatever the purchase price and dividing it by 100. That's how I would do it. So, but that's there for an option. Most of our deals are going to be cash, and we're going to check here. All right, prorations, impounds, and security deposit. Loan interest, property taxes, insurance, and rents shall be prorated at the time and date of closing. All security deposits shall be transferred to the buyer at closing. All impound accounts for taxes and insurance are included in the purchase price shall be transferred to the buyer at closing. Any shortages in these accounts shall be charged to the seller at closing. So if the house is rented and they have they have security deposits on the tenants in there, or rents, or whatever. This just says at closing, the title company is going to prorate those as of the day of closing. All right. In this section, we're talking about the closing of the property and transfer of title, and you're going to put the closing date that you want in here. And I've done it, a month after the contract date. So our contract date was 3/2021. I've listed closing as 4/2021. If you're new at wholesaling, you're not real confident about your cash buyers list, you might want to extend this. You might want to make it for, let's say 45 days or 60 days. So, the contract date is 3/20. You might want to try to make this, 5/20 or 5/15 or whatever, just to give yourself a little bit more time if the seller is willing to do it. All right. So you put your closing date in there, and you put closing date will be held at your title company. So whoever you've selected to be your investor friendly title company in the area. Closing will be held at this title company, and seller agrees to transfer marketable title free and clear from all encumbrances except those listed, and pay any required state taxes or stamps required to record deed and mortgage. Seller agrees to furnish title insurance in the amount of the property purchase price, showing no encumbrances or exceptions other than previously noted. So you're going to go to closing. They're going to pay for title insurance. So nobody ever comes back and says, hey, they didn't really own the property, I owned it. Okay. So if anybody shows up in the future claiming that they have rights to that property, a title company, they issue a title policy that prevents that from ever happening. So if it does happen, you'll be covered, or your buyer will be covered. Okay. And that's called a warranty deed. And typically that's what we want, when we're doing a property. We don't want a quick claim deed. We want a warranty deed, and we want to make sure that that the person that we're buying it from bought on a warranty deed and not a quick claim deed. But really, this is all you need to know right now, that you just need to put your closing date as far out as possible, and your title company in there, and then have the sellers and yourself initial the first page of the contract. Okay, so now let's go on to the second page. All right, this just talks about closing fees. Okay, and the escrow and closing fees. Usually on closing, you're going to put buyer shall pay all escrow and closing fees, because that's what makes one of the reasons it's attractive to sell to a wholesaler, is because you can say, I'll pay all closing costs. Okay. And so you'll mark there, but here's boxes so you can select whatever you want. You can, pay your own closing fees. The seller pays theirs, buyer pays theirs. You can just split it 50-50. You can pay all the fees, or maybe you have them pay the fees. Maybe when you're negotiating, they won't come down on price as much as you want them to, but you can just say, okay, I'll pay what you want for the property, or I'll come up to your price, but you pay the closing costs. So, there's a little room in there for me. Okay. Then we have section 6, damage to the property. And it just, that just says that they're going to keep the property, in the same condition you saw it in. When you go to closing, you want to take possession of the property as it was when you looked at it. Okay. And then if something happens to the property, during the closing period, the buyer may elect to, have it covered by insurance and go ahead and collect the insurance proceeds. So if, your investor's buying it, and let's say they're going to rip it down anyway because they're going to build a brand new house there, they might decide to go ahead and still close on it. So that's in there to cover that kind of scenario. All right, the inspection period. This is big for wholesalers, because it's one of the clauses we use to get out of the contract if we can't find a buyer. So in this section, it just says buyer's obligation to close this transaction are subject to the satisfaction of buyer's inspection and investigation of the property. Buyer shall have until the business day before close of escrow, during which time the buyer will have absolute right to cancel this contract for any reason whatsoever at buyer's sole and absolute discretion. Upon such cancellation, buyer shall be entitled to a return of all earnest money held in escrow, unless buyer gives written notice of cancellation before the expiration date of the inspection period. Then the buyer will be deemed to have elected not to cancel this contract. All right, so in essence, this says that you have until the day before the closing to cancel this deal. All right. If you're going to cancel the deal, I wouldn't wait that long. Don't, somebody expecting to close on the property, don't wait until the last day to cancel. But this gives you the ability to cancel at any time up until the day before closing. All right. The next section 8, is access to the property. And again, wholesaler friendly section here. Between the contract date and close of escrow, seller grants buyer and or buyer's employees, inspectors, partners, investors, contractors, or agents full access to the property as follows. Okay. And if it's vacant, the buyer reserves the right to install a lockbox on the property, which contains a key to the property supplied by the seller. Seller acknowledges and agrees the lockbox will permit access to the property and that it is possible an unauthorized person may go into the property. Buyer is not insuring seller against theft, loss, or vandalism resulting from any unauthorized access. Okay. So, if your seller will agree to this and it's a vacant property, to say, hey, customary, I throw a lockbox on here so my inspectors can get in, so my contractors can come over here and give me a price on rehab, so my partner can swing by, whatever reason, and just have a few lockboxes that you can stick on properties, get a key from them and put it in there. If they won't agree to it, they won't agree to it. But if they will, it makes it a lot easier. Okay. And then the second part of the, that just says, what if somebody breaks in there, well, I've got a lockbox on there, it's not on me. All right. The second is occupied. If the property is occupied by the seller, tenant, or otherwise, as of the contract date, seller will permit the buyer access within 24 hours notice. So it gives, if you call over and say, hey, I've got to walk through there with my inspector or my contractor or whatever, it gives the seller time to call the tenant or, whatever they need to do to get you into the property. Okay. If the property is tenant occupied, here's just some places you can mark that, there's occupancy section, the the tenant will vacate property before the closing of escrow or will continue occupying the property, to applicable and current lease agreement. Seller shall deliver the following to the buyer within 5 days of contract date: current leases of the property, certified rent roll, evidence of security on deposit, if any, on hand. So if it's a tenant occupied property, your investor's buying it as such, he's going to let the tenant stay. You're just requesting a copy of the rent agreements, of escrow, and all those things. So you'll want to check this, either vacant or occupied by tenant. All right, let's scroll down here and continue. Section number, so we'll go over section number 10, but again, you'll initial on this page. Section 10, property turnover. Seller will provide buyer the keys to the property at closing date. All right, that was kind of covered in the above section, but we just wanted to list it there separately. All right, section 11 is debris and personal belongings. This happens a lot with wholesale properties. You'll go into a property and it's either a probate, their parent died or parents passed away or, whatever, or it was a rental property that's full of, garbage because the tenant took off and left everything there. So this is another place where you want to negotiate with the seller. Either they'll clean it out or you'll clean it out. All right. And if you're going to clean it out, keep in mind that when you assign this to an investor, they're going to have to cover this cost. So, a dumpster, depending on where you are, a 30-yard dumpster, costs between, $350 and $450. And you've got to have labor to come haul everything out of the house and throw it in the dumpster. So, if you've just got one dumpster full of stuff, you could be talking, $700, to clean it out. I've wholesaled hoarder houses that have had 5, 6, 7 full dumpsters of stuff, and it was, upwards of 10 grand to do the clean out. So keep this in mind. If you go into a house with a lot of debris, keep that in mind. So you're going to mark it either with debris or without debris. Either they're responsible for cleaning it out or your investor will be. Okay. The next section is just additional personal property. If there's anything in the house that you want to stay, you want to stay for any reason, you would list it here. Say there's an organ sitting there that you want to make sure that they leave in the house, or old piano, or a motorcycle in the garage or whatever. List it there. All right. Then investor disclosure. This is big in a few states now. The one comes to mind is Texas. You have to have this disclosure in your contract. And it just says that seller acknowledges that buyer is an investor and purchases property with the intent to lease, flip, resell, or otherwise make a profit. Seller acknowledges that the purchase price may be less than market value and is willing to sell it as such for convenience, to save time because they have a lack of funds to renovate or update it, and or other personal reasons. Seller waives any claims against any existing equity or added value arising from the property. Buyer has not made seller any representation or promises as to the value of the property in its as is condition. So this is just, making them aware that you're an investor. You're going to do something with this house. You're going to flip it, resell it, or whatever. All right. And they can't come back later and go, oh, they didn't tell me they were an investor. Oh, look how much money they made on the property after I sold it to them. I'm entitled to part of that, or whatever. So this covers your butt in Texas and any other state that comes up with a disclosure law on the books, and prevents any seller from ever coming back and saying they didn't know what you were doing with the property. All right. Lead-based paint acknowledgement. This is required by law that buyer and seller do a lead-based paint acknowledgement. So that's in this contract. That just everybody's aware that houses built prior to 1978 are likely to contain lead-based paint, and everybody's aware of that. Okay, and that just covers the lead-based paint EPA EPA HUD requirements. All right. Representations by the seller. Seller represents and warrants to buyer as follows. Seller has no actual knowledge and has received no notice that the property does not comply with applicable laws governing the use and operation thereof, nor to the seller's actual knowledge does there exist any facts or circumstances on the property which notice or the passage of time would constitute any such violation. As of contract date, seller has not entered into any other agreements or contracts to sell the property. Seller has disclosed to buyer all material latent defects and any other information concerning the property known to seller. So you're just saying, hey, seller, if you know that something about the property doesn't comply with city code, that the sewer's bad and you're not telling me, or anything else, that they're just agreeing that they're telling you the whole story on the property, that here's everything that's wrong with it. Okay. Other agreements. Seller shall not enter into an agreement or contract to purchase with anybody else concerning this property from and after the contract date. Should seller participate in another agreement which will interfere with close of escrow, seller will be responsible for any and all costs and losses to the buyer. This happens, it's never happened to me, but it seems to happen to a lot of wholesalers, that they'll put a property under contract and then they'll find out that the seller put it under contract with somebody else. So this covers you against that. But I'd like to add that, you should make sure you have a deal. And if something seems weird when you're signing the contract, if the seller seems iffy, they don't seem confident of what's going on, or they're not engaged, you probably don't have a deal. All right. So make sure when you're signing this contract that, they're on board with everything, because if they're kind of like, I don't know, then you need to go back through the whole deal and, figure out what their hang up is. But this is in here to protect you. All right. Agency disclosure. Here we're saying seller acknowledges that they have not been represented by the buyer or by any representative of the buyer with respect to the purchase and sale of this property. Seller agrees and understands that the buyer and any of the buyer's representatives are not acting as a seller's broker or agent in the transaction, and have been acting solely for the buyer's own benefit as a principal to this agreement. Seller agrees to hold buyer free from any all liability regarding the property and transaction arising from claims of agency. So we're just saying we're representing ourselves. I'm not doing this for you. I'm doing it for me. So if you want to get representation, get representation. But everybody, me and everybody working for me is working for me and not for you. All right. Assignment and release. So this is our assignment portion. It just says seller agrees and acknowledges that the buyer may assign their rights under this agreement to a wholly or partially owned entity of the buyer or third party that will close directly with the seller. If such an agreement if such an assignment should happen, seller agrees to release buyer from any liability or duties under this contract. So here we're telling them that it's possible that we're going to sign this to somebody else, or a LLC is going to buy the property or whatever. And this is our assignment notice in the contract. Again, have the buyer, have the seller and yourself initial this page. All right, last page here, right to counsel. Seller represents and agrees that seller fully understands seller's rights to discuss all aspects of this contract with an attorney, that seller has carefully read and fully understands all of the provisions of this contract, and that seller freely and voluntarily entered into this contract, and seller has read this document in its entirety and fully understands the meaning, intent, and consequences of this contract. This representation will survive this contract's termination. So this section just says they understand what they're signing. They're agreeing to all of it, and they have right to talk to a real estate attorney, or professional about this contract. Section 20 just says that this agreement shall be governed and construed and enforced under the laws of whatever state you're in. So if you're in, you're in Florida, you're in Illinois, you're in, Pennsylvania, wherever you're at, that's who's going to govern this contract if there's any dispute on it. All right. And then you'll put your county in here, and then again, the state where you're at. Additional terms. If you want to write anything else in here, this is where you would do it, right? If there's been a couple scenarios where there's been a tenant or there's been occupancy past the closing date where my buyer, my end buyer has agreed to let a homeowner stay a little longer past closing date or whatever. That's where you're going to put things like that. And anything extra that's not covered in the contract that you're all agreeing to, put in here. But remember that when you put anything extra in here, your buyer has to agree to it. So if it's not something that is going to be attractive to your cash buyers, don't put it here. Don't put in here that, I agreed to give the seller, 60-day occupancy past closing, because most investors aren't going to want that. All right. So be careful what you put in this section. All right. And then lastly, have the seller sign it. Have them use their legal name, Harold, and, Sally, if it's the legal name, or whatever, use your legal name, date it, and boom, you're done. Okay. You've got the property under contract. So that's it for this video. We're going to get into the other contracts in the other videos. So with that, I'll leave it here and I'll see you in the next video. Thanks.